Hi, everyone. Fernando Alvarez-Perez here with Gateway Litigation. And this is how to draft or how not to draft an international arbitration agreement. In today's video, we're going to take a little bit of a step back and we're going to talk about some more fundamental issues when it comes to drafting international arbitration agreements. So maybe are a lawyer who has to draft a contract that involves cross-border issues, and you've heard that international arbitration is a good idea, right? It's confidential, it's enforceable, it has flexibility, etc., but you don't really know how to draft one. So we're going to talk about what are some of the things that you don't want to do and what are the things you do want to do. And specifically in this video, we're going to talk about specificity. So sometimes in international arbitration agreements, international arbitration practitioners come across some really strange terms and some very strange references to, for example, arbitral institutions and arbitral rules that just don't exist. So I've seen, for example, parties agreeing to arbitration under the international arbitration rules of the United States, which is not really a meaningful statement. It doesn't have the arbitration rules of the United States could refer, I guess, to the FAA and maybe the parts of the FAA that incorporate the New York Convention, but it has no meaning. And so you'll sometimes see nonsensical sort of arbitration agreements, especially where parties are copying and pasting, and then afterwards putting in modifications that they think are relevant to sort of specific circumstances at issue here. So if we want to talk about this issue, let's define just very quickly sort of what is an arbitral institution, and that takes us to what is the difference between institutional arbitration and ad hoc arbitration. So institutional arbitration means that the arbitration will be administered by an institution. So these arbitral institutions often have their own special rules. For example, in the ICC, you will have the ICC rules applying. In the AAA, there are several different types of rules that can apply relating to construction disputes, relating to regular sort of commercial disputes, and so on. But sometimes there are arbitral institutions that have modified rules, or they might have rules that are made by other institutions. Like, for example, Commission on International Trade Law. And there are UNCITRAL rules that apply, and they govern sort of the procedural rules within the arbitration. Institutional arbitration is the norm in international arbitration and sort of cross-border commerce. I think because it takes a lot of burden off of the parties on a lot of sort of procedural issues that they might otherwise have to negotiate, and really just a lot of administrative burden. Ad hoc arbitration, you'll sometimes see some of the major drawbacks are, first of all, of the things that the parties will have to negotiate, especially at a time when they are, in a dispute and not really in the mood to negotiate. And it's also in some countries just not enforceable. So, like in China, for example, ad hoc arbitration is not enforceable in a cross-border context, at least. Um, and so, what's important is making sure that that you're referring to a specific institution and specific arbitral rules if you want those to apply, right? And so the case, and I'll leave a description, is called Marks versus Presstek, and this is a case where things went totally wrong, right? So the parties had agreed to international arbitration, quote, in The Hague under the international arbitration rules, and so it's a little bit strange, right? Because there's no institution mentioned there. The Hague is just a city, and there are multiple arbitration institutions in The Hague. And the international arbitration rules, that's a nonsensical reference. And but the party that was trying to compel arbitration in this case said that this reference meant that the parties had agreed that disputes would be arbitrated in the PCA, the Permanent Court of Arbitration in The Hague, under the UNCITRAL rules. And that the PCA actually rejected the arbitration, and so the party went to court and asked the court to order the parties to arbitrate in the PCA under the UNCITRAL rules, and the court said no. It's completely moot, right? You're asking me to order arbitration in an institution that has already said it won't do it. Um, and so the Presstek case is a little bit of an anomaly because it's unlikely that the court will just say that it will not compel arbitration if you don't, go out of your way to ask for something so specific that's not in the contract. But sometimes parties can ask for institutional arbitration, arguing that maybe there's an imperfect reference in the contract, but really what the parties meant is for to agree to, X arbitral institution, right? Everyone doesn't have to be an arbitration expert to agree to arbitration. Um, And so sometimes you might see that, or sometimes what the court will do is instead it will order ad hoc arbitration because, and this is a very common outcome, it will say, I don't understand the sort of references in this arbitration agreement. They don't make sense, but the parties certainly have agreed to arbitration. And so you'll end up with that. And so what's the best? I think the best sort of practice here is to use model clauses from institutions. So, for example, the PCA actually has a model clause which says that if parties have agreed to the UNCITRAL rules, and the UNCITRAL rules actually have a reference to this, then the PCA can serve as this sort of appointing authority and appoint the arbitrators and perform these certain functions. Um, and the ICC, the International Chamber of Commerce, also has a model clause that you can use to agree to arbitration. That's a lot simpler, actually. It just refers to sort of the ICC rules, and the parties agree that if they're agreeing to the ICC rules, then they're agreeing to ICC institutional arbitration. The point is that by using this model clause, the court will understand exactly what institution you want to use, and will understand exactly what rules you want to use. So that's the video. That's the issue. If you have any more questions about international arbitration or cross-border dispute resolution or litigation in the U.S., or there's any other topic that you'd like to cover, please do leave a comment and let us know. And I hope either way that you will subscribe to the Gateway Litigation YouTube channel. Thanks.